deep in the
Transportation and Public Utilities Law, lifted from Aquino and Hernando 2016, but this is uploaded in 2019 for the sake of commercial law review. Common Carriers, Chapter 1. Contract of Transportation. Person obligates himself to transport persons or property from one place to another for consideration. A person who obligates himself to transport goods or passengers may be a common carrier or a private carrier. There are two kinds. 1. Carriage of passengers. 2. Carriage of goods. Carriage of passengers. The parties are, for common carrier and passenger, carried gratuitously or not. Passenger is defined as one who travels in a public conveyance by virtue of contract, express or implied, with the carrier as to the payment of fare or that which is accepted as an equivalent thereof. Time of perfection. There are two types of contracts of carriage of passengers. 1. Contract to carry. Agreement to carry the passenger at some future date. Consensual contract and perfected by mere consent. Aircraft. Perfected even without issuance of ticket as long as there was already meeting of minds with respect to the subject matter and consideration. If a passenger is carried gratuitously or under a reduced fare, he is still considered as a passenger. However, a stipulation limiting the common carrier's liability for negligence is valid. The case for this review is Baliwag Transit Corporation versus CA. Only the injured person can be considered as a real party in interest who can institute a suit. The parents of the injured party cannot appeal by themselves the dismissal of a case, especially if a release is made by the party injured. There may be cases when the party who contracted for a contract of transportation is not the passenger, such as 1. An employer who hires the services of a bus to ferry its employees to a particular destination. 2. School, which hires services of a bus to transport students so that they can attend an event. Number 2, contract of carriage. Real contract. Not until the facilities of the carrier are actually used can the carrier be said to have assumed the obligation of the carrier, perfected by actual use. Aircraft. Perfected if it was established that the passenger had checked in at the departure counter, passed through customs and immigration, boarded the shuttle bus, and proceeded to the ramp of the aircraft and baggage already loaded to the aircraft. For public utility, bus or jeepneys or streetcars, once it stops, it is in effect making a continuous offer to riders, perfected when passengers already attempting to board the vehicle. For trains, perfected when a person purchases a ticket or possesses sufficient fare with which to pay for his passage. B. Presented himself at the proper place and in a proper manner to be transported. And C. Has a bona fide intention to use facilities of the carrier. Case for reference is British Airways Incorporation versus Honorable Court of Appeals. Even if no tickets were issued, a verbal contract to carry is already a binding consensual contract. In said case, petitioner repeatedly failed to transport contract workers bound for Jeddah. The costs of the tickets were already paid to petitioners, and confirmed bookings were cancelled without prior notice. Thus, petitioner was made liable for its breach of obligation to transport the workers. Note, a bill of lading ticket is a documentary proof of the agreements of both parties, but it is not necessary for the perfection of the contract to carry. Continuing offer rule. Once a public utility bus or jeepney stops, it is in effect making a continuing offer to bus riders. Unless this rule, it is the duty of the drivers to stop their conveyances for a reasonable length of time in order to afford passengers an opportunity to board and enter and they are liable for injuries suffered by boarding passengers resulting from the sudden starting up of the carrier. The liability is already based on a contract. It follows that the passenger is deemed to be accepting the offer if he is already attempting to board the conveyances, and the contract of carriage is perfected from that point. Number 2, carriage of goods. Parties, the shipper and the carrier. Shipper, the person who delivers the goods to the carrier for transportation, pays the consideration or on whose behalf payment is made. Consignee, person to whom the goods are to be delivered, maybe the shipper himself or a third person who is not actually a party to the contract. Perfection, contract to carry goods, consensual. Contract of carriage, act of delivery of goods. Goods are unconditionally placed in the possession and control of the carrier and upon their receipt by the carrier for transportation. Question: when is a consignee bound by the contract? Answer: a consignee may be bound by the agreement between the shipper and the carrier even if the consignee is not the contracting party. In one case, Supreme Court held that consignee is bound by the terms and conditions of the bill of lading, especially when it is established that he accepted the same and is trying to enforce it. In sum, a consignee, although not a signatory to the contract of carriage between the shipper and the carrier, becomes a party to the contract because of 1. The relationship of agency between the consignee and the shipper, 2. The unequivocal acceptance of the bill of lading delivered to the consignee with full knowledge of its contents, and 3. The stipulation per aturi. Case: Compañía Maritima versus Insurance Company of North America. For contract of carriage of goods, the carrier can agree to accept and transport goods at a future date. However, it is perfected only when 1. The goods are placed in the possession and control of the carrier, and 2. Upon its receipt by the carrier for transportation. Note: the receipt of goods is the foundation of the contract of carriage of goods. Thus, even if the goods are not yet loaded on the ship, the contract already exists, especially if the latter accepted the goods and signed as agent. So actual delivery plus acceptance binds the carrier. Question: what is the test to determine whether there is a shipper-carrier relationship? When the control and possession of the goods is in the hands of the carrier and there is nothing else for the shipper to do, then the relationship of shipper and the carrier is established. Carrier, common carriers, persons, corporations, firms, or associations engaged in the business of carrying or transporting passengers or goods or both by land, water, or air for compensation, offering their services to the public, not the means of transportation. On that holds itself out as ready to engage in the transportation of goods for hire as a public employment and not as a casual occupation. Tests to determine whether or not a party is a common carrier of goods. 1. He must be engaged in business of carrying goods for others as a public employment and must hold himself out as a ready to engage in the transportation of goods for persons generally as a business and not as a casual occupation. Number 2, he must undertake to carry good of the kind to which his business is confined. And number 3, he must undertake to carry by the method by which his business is conducted and over his established roads. 4th, transportation must be for hire. Case: First Philippine Industrial Corporation versus CA. True test of common carrier. It is the carriage of passengers or goods, provided it has space for all who opt to avail themselves of its transportation service for a fee. Case: National Steel versus CA. It is not the quantity or extent of the business actually transacted, or the number or character of conveyances used in the activity, but whether the undertaking is a part of the activity engaged in by the carrier that he has held out to the general public as his business or occupation. If the undertaking is a single transaction, not part of the general business or occupation engaged in, as advertised or held out to the general public, the individual or entity is a private, not a common carrier. Case Spouses Pirina versus Spouses Nicholas. Characteristics of common carriers. First, no distinction between one whose principal business is the transportation of persons, goods, and one who does such as an ancillary business or sideline. No distinction between regular or scheduled basis and one offering such service on an occasional, episodic, or unscheduled business. Still, a common carrier, even if services offered to a limited clientele between the general public and a narrow segment of the general population, still considered a common carrier even if he did not secure a certificate of public convenience. No distinction as to the means of transporting, as long as it is by land, water, or air. The Civil Code does not provide that the transportation should be by motor vehicle. Still, a common carrier, even if he has no fixed and publicly known route, maintains no terminals, and issues no tickets. Pipeline operators are common carriers, even if oil or petroleum products are transported through pipelines and not through motor vehicles. The case is First Philippine Industrial Corporation versus CA. Another case, Jose Mendoza, Philippine versus Philippine Airlines. The test of whether one is a common carrier by air is whether he holds out that he will carry for hire, so long as he has room, goods, or everyone bringing goods to him for carriage, not whether he is carrying a public employment or whether he carries to a fixed place. Diligence versus CA. Private respondent was considered a common carrier, although his principal business was a junk dealer. On his return trips to Pangasinan after selling junk materials in Manila, respondent would load his vehicles with cargo, which various merchants wanted delivered in establishments in Pangasinan. For that service, respondent charged freight rates that were commonly lower than regular commercial rates. Thus, even if the transportation of goods was merely ancillary to the main business of buying and selling used bottles and scrap metals, the Supreme Court considered the respondent a common carrier. Charter party. A contract by which an entire ship or some principal part thereof is let by the owner to another person for a specific time or use. Note, a charter party is a written contract or instrument, not a person. What is the effect of a charter party? It may transform a common carrier into a private carrier. However, it must be a bareboat or a demise charter where the charter mans or the charterer mans the vessel with his own people and becomes, in effect, the owner of the voyage or service stipulated. Two types. One, contract of affreightment. Involves the use of shipping space on vessels leased by the owner in part or as a whole to carry goods for another. Common carrier. Observe extraordinary diligence in case of loss, deterioration, or destruction of goods. Common carriers are presumed to be at fault or have acted negligently. Two types of affreightment. One, time charter. Vessel is leased to the charterer for a fixed period of time. Two, voyage charter. Ship is leased for a single voyage. Number two, charter by demise or bareboat charter. The whole vessel is let to the charterer with a transfer to him of its entire command and possession and consequent control over its navigation, including the master and the crew, who are his servants. Charter includes both vessel and crew. Common carrier becomes private carrier insofar as that particular voyage is concerned. If it is already a private carrier, ordinary diligence in the carriage of goods will suffice. Private carrier, undertaking as a single transaction, not a part of the general business or occupation. Although involving the carriage of goods for a fee, no presumption of negligence applies. Whosoever alleges damage to or deterioration of the goods carried has the burden of proving that the cause was the negligence of the carrier. Distinction between common carriers and private carriers. For common carrier, extraordinary diligence in the vigilance over the goods they carry. Private carrier, ordinary diligence in the carriage of goods will suffice. In case of loss, under common carrier, destruction, or deterioration of goods, they are presumed to have been at fault or to have acted negligently. Burden of proving otherwise rests on them. Under private carrier, no such presumption applies to private carriers, for whosoever alleges damage to or deterioration of the goods carried has the onus of proving that the cause was the negligence of the carrier. Now, under common carrier, it cannot stipulate that it is exempt from liability for the negligence of its agents or employees, while under private carrier, it may validly enter into such stipulation. Factors to be considered whether a carrier is common or private. The law applicable is the Civil Code, common carrier, and for private, it's contract. Diligence required, common carrier, extraordinary diligence, private, diligence of a good father of a family. Burden of proof in relation to negligence. The common carrier, the carrier. Private, on the party having a claim against the carrier. The case the Planters Producers Incorporation versus CA. It is therefore imperative that a public carrier shall remain as such, notwithstanding the charter of the whole or portion of a vessel by one or more persons, provided the charter is limited to the ship only. As in the case of a time charter or voyage charter, it is only when the charter includes both the vessel and its crew that a common carrier becomes private. Generally, private carrier or private carriage is undertaken by special agreement, and the carrier does not hold himself out to carry goods for the general public. The case is Ca Presumption versus CA and Caravan Travel and Tours International. By definition, a contract of carriage is one whereby a certain person or association of persons obligate themselves to transport person, thing, or new from one place to another for a fixed price. It is obvious from the above definition that respondent is not an entity engaged in the business of transporting either passengers or goods, and is therefore neither a private nor a common carrier. Its covenant with its customer is simply to make travel arrangements in their behalf. It is in this sense that the contract between the parties in this case was an ordinary one for services and not one of carriage. It is thus not bound under the law to observe extraordinary diligence in the performance of its obligation. Common carrier versus towage, arrastre, and stevedoring. Towage. A vessel is hired to bring another vessel to another place. Example, a tugboat may be hired by common carrier to bring the vessel to a port. Operator of tugboat is not a common carrier. In maritime law, towing for the mere purpose of expediting her voyage without reference to any circumstances of danger. Arrastre. Arrastre operators' functions has nothing to do with the trade and business of navigation, nor to the use or operation of vessels. Services are not maritime. The functions of arrastre operator is to receive, handle, care for, and deliver all merchandise imported and exported upon or passing over government-owned wharves and piers in the port. Recorder check all merchandise which may be delivered to said ports and shipside. Furnish light and water services and other incidental services in order to undertake its arrestor service. Such service is in phase no different from those of a depository or warehouse man. Stevedoring involves the loading and unloading of coastwise vessels calling at the port. Travel agency, the object of a person who purchases tickets from a travel agency is only its services of arranging and facilitating the booking, ticketing, and accommodation in a package tour. The contract is not a contract of carriage but a contract of service. Common carriers are public utilities impressed with public interest and concern, subject to regulation by the state. If the use is merely optional or the public benefit merely incidental, it is not public use, authorizing the jurisdiction of the Public Utility Commission. There must be, in general, a right which the law compels the power to give to the general public. True criterion, whether the public may enjoy it by right or by permission. Governing laws. Article 1766 of the Civil Code, in all matters not regulated by this code, the rights and obligations of common carriers shall be governed by the Code of Commerce and by special laws. Article 1753. The law of the country to which the goods are to be transported shall govern the liability of the common carrier for their loss, destruction, or deterioration. Summary of rules. Coastwise shipping. NCC Article 1732 to 1766 as the primary law. Code of Commerce suppletorily in absence of NCC provision. Carriage from foreign ports to Philippine ports. The new Civil Code is the primary law, followed by the Code of Commerce in all matters not regulated by the new Civil Code. We also have the COGSA, supplementary to the new Civil Code. Carriage from Philippine ports to foreign ports, the laws of the country to which the goods are being transported, like Article 1753. The overland transportation, primary law is the new Civil Code, and supplementary is the Code of Commerce. Air transportation, Civil Code, Code of Commerce, and for international carriage, Warsaw Convention with amendments. Note, COGSA is the primary law under RA 10668. Nature of business. Common carriers exercise sort of business office. Consequently, common carriers are subject to regulation by the state. Registered owner rule, registration laws. Governed by the Land Transportation and Traffic Code and administered by the Land Transportation Office. There is a compulsory registration of motor vehicles under Section 5 of RA 4136 or Land Transportation and Traffic Code. Registered owner rule. Registered owner of a vehicle is liable for any damage caused by the negligent operation of the vehicle, although the same was already sold or conveyed to another person at the time of the accident. The registered owner is liable to the injured party subject to his right of recourse against the transferee or the buyer, applicable in case of lease. Registered owner not liable if vehicle was taken from him without his knowledge and consent. What is the purpose of such law? The main aim of motor vehicle registration is to identify the owner, that if any accident happens or that any damage or injury is caused by the vehicle on the public highways, responsibility therefore can be fixed on a definite individual, the registered owner. Cabit system. The registered owner rule is applicable to people involved on a cabit system, arrangement whereby a person who has been granted a certificate of public convenience allows other persons who own motor vehicles to operate them under his license, sometimes for a fee or percentage of the earnings, contrary to public policy, thus void and inexistent under Article 1409 of the Civil Code. Parties to the cabit system cannot invoke the same as against each other, either to enforce their legal agreement or to invoke the same to escape liability. This is consistent with the time-honored maxim ex facto, illicito, non-auditor action. No action arises from an illicit bargain. Pari delicto rule. Having entered into an illegal contract, neither can seek relief from the courts, and each must bear the consequences of his acts. Note, the policy against cabit system is also applicable to aircraft and vessels. Basic rule that no person can operate a common carrier without securing a certificate of public convenience and necessity. Hence, persons who do not have such certificate cannot circumvent the law by using the certificate of another. The thrust of the law in enjoining the cabit system is not so much as to penalize the parties but to identify the person upon whom responsibility may be fixed in case of an accident with the end view of protecting the riding public. Case Dizon versus Octavio. The primary factors considered in the granting of a certificate of public convenience for the business of public transportation is the financial capacity of the holder of the license so that liabilities arising from accidents may be duly compensated. Thus, for the safety of passengers and the public who may have been wronged and deceived through the baneful cabit system, the registered owner of the vehicle is not allowed to prove that another person has become the owner so that he may be thereby relieved of responsibility. Boundary system. System where carriers impose an amount that such drivers would need to remit or pay to the carrier every day. This amount to be remitted or paid is called the boundary. The excess of the amount the drivers earn daily will be their compensation. It is also considered a form of lease of the vehicle being used, mostly common in taxi operators. Under this system, the carrier cannot escape liability by claiming that the driver is a lessee. To tolerate such position would not only abet flagrant violation of the public service law, but also place the riding public at the mercy of reckless and irresponsible drivers. Reckless because the amount they earn depends upon the number of trips they make, hence the speed at which they drive, and responsible because most, if not all, of them are in no position to pay for the damages they might cause. Obligation of the parties. Basic obligation of the common carrier: to accept passengers and goods without discrimination, 2. To deliver or seasonable deliver the goods, 3. To bring the passenger to the proper place or destination, 4. To deliver the goods to the proper person, and 5. To exercise extraordinary diligence in the performance of its duties. Obligation of the carrier: duty to accept. A common carrier granted a certificate of public convenience is duty-bound to accept passengers or cargo without any discrimination. It is illegal for domestic ship operators to refuse to accept or carry passengers or cargo without just cause. That's under Section 16 RA 9295. Note, in air transportation, passengers with confirmed tickets who were not allowed to board are provided with denied boarding compensation and priority boarding rules. No compensation for refusal if it is because of 1. Government requisition of the space, 2. Substitution of equipment of lesser capacity when required by operational and or safety, or other causes beyond the control of the carrier, and 3. If arrangements have been made for the passenger to take another flight in a comparable air transportation which will arrive not later than 3 hours after the time of flight on which the confirmed space is held is supposed to arrive. Civil Aeronautics Board Economic Regulation. Grounds for valid refusal to accept goods. General rule: common carriers cannot lawfully decline to accept a particular class of goods. Exception: if it appears that for some sufficient reason the discrimination against the traffic in such good is reasonable and necessary. Because it is 1. Dangerous objects or substances including dynamites and other explosives. 2. Goods are unfit for transportation. 3. Acceptance would result in overloading. 4. Contrabands or illegal goods. 5. Goods injurious to health. 6. Goods will be exposed to untoward danger like flood, capture by enemies, and the like. And 7. Goods like livestock will be exposed to disease. Number 8. Strike. Number 9. Failure to tender goods on time. Case is Fisher versus Yanko. Factors in determining reasonable discrimination include suitability of the vessel for the transportation of such products, reasonable possibility of danger or disaster resulting from their transportation in the form and under the conditions in which they are offered for carriage, and 3. The general nature of the business done by the carrier. Hazardous and dangerous substances. Carrier not properly equipped to transport dangerous chemicals or explosives may validly refuse to accept the same for transport. Those which are not authorized by the maritime industry authority to carry such goods may also validly refuse the same for transport. There must be a special permit to carry from the marina, except only if the said cargoes are covered by the necessary clearance from appropriate government agencies. Unfit for transport. Carriers may refuse to accept goods that are unfit for transportation. These goods may by nature be unfit for transportation or are unfit because of improper packaging or defect in their containers. However, carriers may accept the goods and limit its liability by stipulation. Inspection. If by reason of well-founded suspicion of falsity in the declaration as to the contents of the package, carrier should decide to examine and investigate it in the presence of witnesses, with the shipper and consignee in attendance. If declaration of shipper is true, expenses occasioned by the examination and of repacking the packages shall be for the account of the carrier. Even if the cost of the loss, destruction, or deterioration of the goods should be caused by the character of the goods, or the faulty nature of the packaging, or of the containers, the common carrier must exercise due diligence to forestall or lessen the loss. A carrier is entitled to fair representation of the nature and value of the goods to be carried, with the concomitant right to rely thereon, and further nothing this juncture that a carrier has no obligation to inquire into the correctness or sufficiency of such information. The consequent duty to conduct inspection thereof arises in the event that there should be reason to doubt the veracity of such representations. Duty to deliver the goods. Time of delivery. Where a carrier has made an express contract, the goods must be delivered within a specified time, otherwise he is liable for any delay, indemnity for damages. In the absence of any agreement, goods must be delivered at its destination within a reasonable time, depending on the attending circumstances. Nature of the goods, expected date of arrival may be considered. In this absence of a special contract, a carrier is not an insurer against delay in transportation of goods. Reasonable time, expected date of arrival may be considered in determining. In Maersk versus CA, 2 months was considered as unreasonable. However, it will also depend on the nature of the goods. If perishable, it should be delivered with haste or before it is damaged or becomes rotten. Consequences or effects of delay. Excusable delays in carriage suspend, but do not generally terminate the contract of carriage when the cause is removed. The master must proceed with the voyage and make delivery. During the detention of or delay, vessel continues to be liable as a common carrier, not a warehouse man, and remains duty-bound to exercise extraordinary diligence. If delay is legally inexcusable, the following consequences result. 1. The carrier is still liable even if natural disaster caused the damage. 2. The stipulation limiting the liability of the carrier cannot be availed of or is inoperative. Number 3, the carrier is liable for damages used by the delay. And fourth, the consignee may exercise his right to abandon under Article 371 of the Code of Commerce. Article 1740. If common carrier negligently delays in transporting the goods, a natural disaster shall not free it from responsibility. Article 1747. If common carrier delays without just cause in transporting the goods or changes the stipulated or usual route, the contract limiting its liability cannot be availed of in case of the loss, destruction, or deterioration of the goods. Abandonment. In case of delay through the fault of the carrier, the consignee may refuse to accept the goods or may leave the goods in the hands of the carrier. It must be communicated to the carrier in writing. This right must be exercised between the time of delay and before the arrival of the goods at its destination. The carrier must pay the full value of the goods, as if they had been lost or mislaid. Note, if abandonment is not made, indemnification for the losses and damages by reason of the delay cannot exceed the current price which the goods would have on the day and at the place they are to be delivered. The value of the goods which the carrier must pay in case of loss or misplacement shall be that what is declared in the bill of lading. Consignee must not defer the payment of the expenses and transportation charges of the goods, otherwise carrier may demand the judicial sale of the goods. Case Magellan Manufacturing Marketing Corporation versus CA. Abandonment may also be made by virtue of a stipulation or agreement between parties. Number 2, rights of passengers in case of delay. As to the rights and duties of the parties strictly arising out of delay, the Civil Code is silent. However, the Code of Commerce provides for such a situation. Article 698. In case of a voyage already begun should be interrupted, the passengers shall be obliged to pay the fare in proportion to the distance covered, without right to recover for losses and damages if the interruption is due to fortuitous event of force majeure, but with the right to indemnify if the interruption should have been caused by the captain exclusively. If the interruption should be caused by the disability of the vessel, and a passenger should agree to await the repairs, he may not be required to pay any increased price of passage, but his living expenses during the stay shall be for his own account. Note, the carrier is liable for any loss or damage, including any pecuniary loss or loss of profit, which the passenger may have suffered by reason thereof. In case the vessel is not able to depart on time, and the delay is unreasonable, the passenger may opt to have his or her ticket immediately refunded without any refund service fee from the authorized issuing or ticketing office. Where and to whom delivered. Place. Goods should be delivered to the consignee in the place agreed upon by the parties. The shipper may change the consignment of the goods provided that at the time of ordering the change of the consignee, the bill of lading signed by the carrier be returned to him in exchange for another wherein the novation of the contract appears. The expenses occasioned by the change shall be for the account of the shipper. Consignee. Delivery must generally be made to the owner or consignee or to someone lawfully authorized by him to receive the goods for his account or to the holder of the negotiable instrument. Article 369, Code of Commerce. If the consignee cannot be found at the residence indicated in the bill of lading, or if he refuses to pay the transportation charges and expenses, or if he refuses to receive the goods, the municipal judge, where there is none of the first instance, shall provide for their deposit at the disposal of the shipper, this deposit producing all the effects of delivery without prejudice to third parties with a better right. Delay to transport passengers. A carrier is duty bound to transport the passenger with reasonable dispatch. Interruption of voyage. No right to recover if force majeure, with right to recover is if caused by the captain exclusively. If passengers agree to wait, no additional payment for boarding fee, but the leaving expenses are for their account. Effects of delayed and unfinished voyage in inter-island vessels. Vessels cannot continue or complete her voyage for any cost. Carrier is under obligation to transport the passenger to his or her destination at the expense of the carrier, including free meals and lodging before the passenger is transported to his or her destination. The passenger may opt to have his or her ticket refunded in full if the cost of the unfinished voyage is due to the negligence of the carrier or to an amount that will suffice to defray transportation costs at the shorter possible route if the cost of the unfinished voyage is fortuitous event. If vessel is delayed in arrival at the port of destination, free meals during mealtime. Delay in departure at the point of origin due to carrier's negligence, fortuitous event, free meals during mealtime, carrier not obliged to serve free meals. The carrier is not obliged to inform passengers of sailing schedule of the vessel. Duty to exercise extraordinary diligence. Goods should be delivered in the same condition that they were received and to transport the passengers without encountering any harm or loss. Article 1755. A common carrier is bound to carry the passengers safely as far as human care and foresight can provide, using the utmost diligence of very cautious persons with a due regard for all the circumstances. Extraordinary diligence. It requires the common carrier to know and follow the required precaution for avoiding damage to or destruction of the goods entrusted to it for safe carriage and delivery. It requires common carriers to render service with the greatest skill and foresight and use all the reasonable means to ascertain the nature and characteristics of goods tendered for shipment, and to exercise due care in the handling and stowage, including such methods as their nature requires. The case is Campanilla Maritima versus CA. Presumption of negligence. Two conditions for the birth of the presumption of negligence. 1. There exists a contract between the passenger or the shipper and the common carrier. 2. The loss, deterioration, injury, or death took place during the existence of the contract. Note, the presumption is operative even if the parties cannot establish the cause of damage to the goods or injury to the passenger. Article 1735 of the Civil Code provides, in all cases other than those mentioned in numbers 1, 2, 3, 4, and 5 of the preceding article, if the goods are lost, destroyed, or deteriorated, common carriers are presumed to have been at fault or to have acted negligently unless they prove that they observe ordinary diligence as required in Article 1733. Article 1756. In case of death or injuries to passengers, common carriers are presumed to have been at fault or to have acted negligently unless they prove that they observe extraordinary diligence as prescribed in Articles 1733 and 1755. Why should common carriers exercise extraordinary diligence? To protect the passengers from tragic mishaps that frequently occur in connection with modern transportation. This high standard of care is imperatively demanded by the preciousness of human life and by the consideration that every person must in every way be safeguarded against all injury. Note, this extraordinary liability lasts from the time the goods are placed in the possession of the carrier until they are delivered to the consignee or to the person who has the right to receive them. But these provisions only when loss, destruction, or deterioration takes place while the goods are in the possession of the carrier and not after it has lost control of them. Note, the statutory presumption may only be overcome by evidence that the carrier exercised extraordinary diligence. There is no presumption of bad faith, even if there is a presumption of negligence. Bad faith should be established by clear and convincing evidence. The law always presumes good faith, such that any person who seeks to be awarded with damages due to the acts of another has the burden of proving that the latter acted in bad faith or with ill motive. That's in the case of Air France versus Gallego. Doctrine of proximate cause. It is not applicable. There is a presumption of negligence. If the goods are lost, destroyed, or deteriorated, common carriers are presumed to have acted negligently unless they prove that they observe extraordinary diligence. In case of death or injuries to passengers, common carriers are presumed to have been at fault or to have acted negligently unless they prove that they observe extraordinary diligence. It was repeated for emphasis. Effect of acquittal. The acquittal of the employee of the common carrier in the criminal case is immaterial to the case for breach of contract. Article 31 of the NCC provides, when the civil action is based on an obligation not arising from the act or omission complained as a felony, such civil action may proceed independently of the criminal proceedings and regardless of the result of the latter. Duration of duty in carriage of goods. Due diligence should be exercised the moment the goods are delivered to the carrier. When are goods deemed delivered to the carrier? The goods are deemed delivered to the carrier when the goods are ready for and have been placed in the exclusive possession, custody, and control of the carrier for the purpose of their immediate transportation, and the carrier has accepted them. When the carrier has thus accepted such delivery, the liability of the carrier commences iu instanti. As to its termination, it was ruled that the obligation of the carrier could also be considered terminated despite the non-surrender of the bill of lading. Temporary unloading of storage. Article 1737 of the New Civil Code provides that the common carrier's duty to observe extraordinary diligence over the goods remains in full force and effect, even when they are temporarily unloaded or stored in transit. Stoppage in transitu. By way of exception under Article 1737, extraordinary diligence need not be exercised over the goods that are unloaded temporarily if the shipper or owner has made use of the right of stoppage in transitu. What is stoppage in transitu? It is the right of an unpaid seller to resume possession of the goods at the time while the goods are in transit, and he will become entitled to the same rights in regards to the goods as he would have had if he had never parted with the possession. The right is available if the buyer of goods is or becomes insolvent. Number 2, the unpaid seller has parted with the possession of the goods. And 3, the goods are still in transit. The carrier becomes an ordinary bailee. Diligence up to delivery. The extraordinary responsibility of the common carrier lasts until the time the goods are actually or constructively delivered by the carrier to the consignee or the person who has the right to receive them. Delivery to custom authorities. The goods remain to be the responsibility of the carrier if they are still in the hands of customs officials. The solution for the carrier is to stipulate in the bill of lading that the carrier has or shall not be liable for any losses while the goods are in the custody of the Bureau of Customs. Commencement of duty in carriage of passenger. In the case of trains, perfected when a person purchased a ticket, possesses sufficient fare with which to pay for his passage. B. Presented himself at the proper place and in a proper manner to be transported. C. Has a bona fide intention to use facilities of the carrier. Carriage by sea. The duty of the carrier commences as soon as the person with bona fide intention of taking passage places himself in the care of the carrier or its employees and is accepted as a passenger. Land transportation, public utility bus or jeepneys or streetcars. Once it stops, it is in effect making a continuous offer to riders, perfected when passenger is already attempting to board the vehicle. How is duty complied with? No hard and fast rule in the exercise of extraordinary diligence. The law does not require a formula. Statutory duties to passengers, Article 1759 and 1763. That is 1759 and 1763. Article 1759. Common carriers are liable for the death of or injuries to passengers through the negligence or willful acts of the former's employees, although such employees may have acted beyond the scope of their authority or in violation of the orders of the common carrier. Article 1763. Common carriers is responsible for injuries suffered by a passenger on account of the willful acts or negligence of another passenger or of strangers. If the common carrier's employees, through the exercise of diligence of a good father of a family, could have prevented or stopped the act or omission. Duty to third persons. The duty to exercise extraordinary diligence is primarily owed to the passengers and the goods that are being transported. Exception: Capillarian Bus Lines versus Coronado. The court ruled that for if common carriers carefully observed the statutory standard of extraordinary diligence in respect of their own passengers, they cannot help but simultaneously benefit the pedestrian and the owners and passengers of other vehicles who are equally entitled to the safe and convenient use of our roads and highways. Effect of a stipulation on extraordinary diligence. Under goods, the parties cannot stipulate that the carrier will not exercise any diligence in the custody of goods. However, Article 1744 provides a stipulation between the common carrier and the shipper or owner limiting the liability of the former for the loss, destruction, or deterioration of the goods to a degree less than extraordinary diligence shall be valid, provided it be in writing, signed by the shipper or owner, supported by a valuable consideration other than that services rendered by the common carrier, and 3, reasonable, just, and not contrary to public policy. Under passengers, there can be no stipulation lessening the utmost diligence that is owed to passengers. Gratuitous passengers. A stipulation limiting the common carrier's liability for negligence is valid, but not for willful acts of gross negligence. The reduction of fare does not justify any limitation. Lara versus Valencia. Diligence owed to accommodation passengers is only ordinary diligence. However, this case is not controlling with respect to common carriers because the defendant in the said case was not a common carrier. Extraordinary diligence also required even if the passenger is carried gratuitously. No, reduction of fares does not justify any limitation of the common carrier's liability. Extraordinary diligence in carriage by sea. Seaworthiness. Warranty of seaworthiness of ship. This is the first step that should be undertaken. Extraordinary diligence requires that the ship, which will transport the passengers and goods, is seaworthy. Seaworthiness of the vessel is impliedly warranted. The carrier shall be bound before and at the beginning of the voyage to exercise due diligence to make the ship seaworthy. Letter B. No duty to inquire. Because of the implied warranty of seaworthiness, shippers of goods, when transacting with common carriers, are not expected to inquire into the vessel's seaworthiness, genuineness of its licenses, and compliance with all maritime laws. Passengers cannot be expected to inquire every time they board a common carrier whether the carrier possesses the necessary papers or that all the carrier's employees are qualified. It is the carrier that carries such burden of proving that the ship is seaworthy. Sufficient evidence must be submitted, and the presentation of certificates of seaworthiness is not sufficient to overcome the presumption of negligence. Meaning of seaworthiness: a vessel must have such degree of fitness which an owner who is exercising extraordinary diligence would require his vessel to have at the commencement of the voyage, having regard to all the probable circumstances of it. This includes fitness of the vessel itself to withstand the rigors of voyage, fitness of the vessel to store the cargoes and accommodate passengers to be transported, and that it is adequately equipped and properly manned. Seaworthiness is that strength, durability, and engineering skill made as a part of a ship's construction and continued maintenance, together with a competent and sufficient crew, which would withstand the vicissitudes and dangers of the elements which might reasonably be expected or encountered during her voyage without loss or damage to her particular cargo. Example: the carrier was able to establish that the ship itself was seaworthy because the records reveal that the vessel was dry docked and inspected by the Philippine Coast Guard before its first destination. A warranty of seaworthiness requires that it be properly laden and provided with a competent master, a sufficient number of competent officers and seamen, and the requisite appurtenances and equipment. The carrier shall be bound before and at the beginning of the voyage to exercise due diligence to: 1. Make the ship seaworthy. 2. Properly man, equip, and supply the ship. 3. Make all parts of the ship in which goods are carried fit and safe for their reception, carriage, and preservation. The carrier shall properly and carefully load, handle, stow, carry, keep, care for, and discharge the goods carried. Note: seaworthiness is relative, and its construction and its application depends on the facts of a particular case, like length and nature of the voyage. Fitness of the vessel itself: it is necessary that the vessel can be expected to meet the normal hazards of the journey. General test of seaworthiness: whether the ship and its appurtenances are reasonably fit to perform the service undertaken. The ship must be cargo worthy. Even if the vessel was properly maintained and is free from defect, the carrier must not accept the goods that cannot properly be transported in the ship. The ship must be efficiently strong and equipped to carry the particular kind of cargo which she has contracted to carry, and her cargo must be so loaded that it is safe for her to proceed on her voyage. The vessel must be adequately equipped and properly manned. On top of regular maintenance and inspection, captains, masters, or patrons of vessels must prove the skill, capacity, and qualifications necessary to command and direct the vessel. If the owner of a vessel desires to be the captain without having the legal qualifications, he shall limit himself to the financial administration of the vessel and shall entrust the navigation to a qualified person. Note: it is not an excuse that the carrier cannot afford the salaries of competent and licensed crew, or that latter is unavailable. Adequate equipment. With respect to vessels that carries passengers, the Maritime Industry Authority prescribes rules which provide for indispensable equipment and facilities, like exit doors, lifeboats, and life vests. Overloading. Duty to exercise due diligence likewise includes the duty to take passengers or cargoes that are within the carrying capacity of the vessel. Proper storage. The vessel itself may be suitable for the cargo, but this is not enough because the cargo must also be properly stored. Cargo must generally not be placed on deck. The carrying of deck cargo raises the presumption of a sea unworthiness. unless it can be shown that the deck cargo will not interfere with the proper management of the ship. Negligence of captain and crew. Failure on the part of the carrier to provide competent captain and crew should be distinguished from the negligence of the said captain and crew, because the latter is covered by the limited liability rule. Liability of the ship owner may be limited to the value of the vessel. If the negligence of the captain and crew can be traced to the fact that they are really incompetent, the limited liability rule cannot be invoked because the ship owner may be deemed negligent. Rules on passenger safety. Negligence on the part of the captain and crew, as well as the operator, includes failure to comply with the regulation issued by the maritime industry. Memorandum Circular Number 112. Passengers do not merely contract for transportation because they have the right to be treated by the carrier and its employees with kindness, respect, courtesy, and due consideration. They are entitled to be protected against personal conduct, injurious language, indignities, and abuses from the said carrier and its employees. Planters Products Incorporated versus CA. The period during which private respondent was to observe the degree of diligence required of it as a public carrier began from the time the cargo was unconditionally placed in its charge after the vessel's holds were duly inspected and passed scrutiny by the shipper, up to and until the vessel reached its destination and its hull was re-examined by the consignee, but prior to unloading. A ship owner is liable for damage to the cargo resulting from improper stowage only when the stowing is done by stevedores employed by him and therefore under his control and supervision, not when the same is done by the consignee or stevedores under the employ of the latter. Deviation and transshipment. Deviation. If there is an agreement between the shipper and the carrier as to the road over which the conveyance is to be made, subject to the approval of the Maritime Industrial Authority, the carrier may not change the route unless it is by reason of force majeure. Without this cause, he shall be liable for all the losses which the goods may suffer, aside from paying the sum stipulated for that case. When on account of the force majeure, the carrier had to take another route, which resulted to an increase in transportation charges, he shall be reimbursed upon formal proof. Now, with respect to carriers by sea, the routes are subject to approval by Marina, and the same cannot generally be changed without the authorization from said administrative agency. Transshipment. The act of taking cargo out of one ship and loading into another to transfer goods from the vessel stipulated in the contract of affreightment to another vessel before the place of destination named in the contract has been reached. Transshipment of freight without legal excuse is a violation of the contract and subjects to the carrier liability if the freight is lost even by a cause otherwise expected. Note, there is a transshipment whether or not the same person, firm, or entity owns the vessel. What matters is the actual physical transfer of cargo from one vessel to another. Extraordinary diligence in carriage by land. Condition of vehicle. Common carriers that offer transportation by land are similarly required to make sure that the vehicles that they are using are in good condition and order. Rule on mechanical defects. If the carriers will replace certain parts of the motor vehicle, they are duty bound to make sure that the parts they are purchasing are not defective. Hence, it is a long-standing rule that a carrier cannot escape liability by claiming that the accident that resulted because of a defective brake or tire is due to a fortuitous event. This is true even if it can be established that the tire that was subject of a blowout is brand new. The duty to exercise extraordinary diligence requires the carrier to purchase and use vehicle parts that are not defective. Traffic rules. The carrier fails to exercise extraordinary diligence if it will not comply with basic traffic rules. The Civil Code provides for a presumption of negligence in case the accident occurs while the operator of the motor vehicle is violating traffic rules. In cases involving breach of contract of carriage, proof of violation of traffic rules confirm that the carrier failed to exercise extraordinary diligence. Malari, Senior and Junior versus CA. This rule is settled that a driver abandoning his proper lane for the purpose of overtaking another vehicle in an ordinary situation has the duty to see to it that the road is clear and not to proceed if he cannot do it safely. Diligence in the selection and supervision. In quasi-delict cases under 2176 in relation to Article 2180 of the new Civil Code, the employer can invoke the defense of due diligence in selection and supervision of the employee in order to escape liability. Such a defense is not available if the case against the carrier is based on contract or culpa contractual. Under 1759, common carriers are liable for the death of or injuries to passengers through the negligence or willful acts of the former's employees, although such employees may have acted beyond the scope of their authority or in violation of the orders of the common carriers. This liability of the common carriers does not cease upon proof that they exercise all the diligence of a good father of a family in the selection and supervision of their employees. Duty to inspect. There is no unbending duty to inspect each and every package or baggage that is being brought inside the bus or jeepney. The carrier is duty bound to conduct such inspection depending on the circumstances. In Nocum versus Laguna Tayabas Bus Company, it is true that the passengers of appellant's bus should not be made to suffer for something over which they had no control. Fairness demands that in measuring a common carrier's duty towards its passengers, allowance must be given to the reliance that should be reposed on the sense of responsibility of all the passengers in regard to their common safety. It is to be presumed that a passenger will not take with him anything dangerous to the lives and limbs of his co-passengers, not to speak of his own. Not to be lightly considered is the right to privacy to which each passenger is entitled. In other words, injury may be verbally made as to the nature of a passenger's baggage when such is not outwardly perceptible. But beyond this, constitutional boundaries are already in danger of being transgressed. Supreme Court held that carrier has succeeded in rebutting the presumption of negligence by showing that it has exercised extraordinary diligence for the safety of its passenger, according to the circumstances of each case. Note, although overland transportation are not bound nor empowered to make an examination on the contents of packages or bags, particularly those hand-carried by passengers, such is different with regards to an airline company. Insurance. The Insurance Code, as amended, requires all motor vehicles to be covered by compulsory motor vehicle liability insurance that compensates, among others, passengers who died or who suffered bodily injuries as of the operation of the motor vehicle. Carriage by train. Competent employees. The carrier must hire competent engineers and employees. The train operator is liable for breach of contract if the negligence of the employee caused damage to passengers. That's Article 1759. The platform must be safe. Light Rail Transit Authority et al. Versus Marjorie Navidad et al. The train operator was made liable although the death of the victim was sustained while the victim was still waiting for a coach on the platform of the LRT station.